法定人數。
Members, we have formed a quorum. We need nominations for chairman. I second that. Okay.
喂，幾多次開幾多次會？開幾多次會嘅？
有冇法律顧問？有冇咩？
我冇嘢問。
好啊，我哋請官員入嚟先。
我冇嘢問。
Please invite the officials to join us.
嗰個LLP 啫嘛。
係啦，
就係改
最後呢兩條
嘛。
佢就再徵詢律師會，佢可以。
仲要徵詢律師會？
佢話嗰個日期都問一問律師會。
邊個日期啊？
成個 LLP 嗰個amendment我哋
哦，幾時生效啊嘛？
係啦。
因為咗有足夠時間翻去內會匯報咧，咁我哋都建議延展。
盡快啊！
咁咪10月4號延展，即係動議延展。
得，冇問題。咁少人又得一個。
有4個。
尹女士得啦，一個搞掂啦。
One.
好，歡迎官員嚟到。
I'd like to welcome all government officials. So over to you, Ms. Wen, for an introduction. Before members are two sets of rules. First, rules of the High Court Amendment Number 3, Rules 2015, and secondly, rules of the District Court Amendment Rules 2015. The two sets of rules are identical in contents. They are for the amendment of High Court rules and District Court rules, Order number 81. Order 81 of the two sets of rules provide for procedural matters in relation to the legal practitioners. As you may be aware, that through the Legal Practitioners Amendment Ordinance 2012, we introduced the limited liability partnership for solicitors firms in Hong Kong. And in the future, if there are proceedings initiated against such LLPs, and when it comes to enforcement, there's some special arrangements applicable. Then that's why we need to amend the two sets of rules. So if it's an LLP, the innocent partners will not be held liable for the negligence of other partners in the provision of professional services. So that's in relation to the joint and several liabilities. If there's a judgment against an LLP, so as far as the innocent partner is concerned, he will not be liable. And his liability, the liability of innocent partner, is only in relation to the assets held in the LLP. So that's my brief introduction to the matters under consideration. Well, the ordinance was passed a long time ago, and the legal sector has been waiting for quite a long time for the introduction of the LLP arrangement. I understand this is the last piece of the jigsaw puzzle. So are you ready in all other aspects? Well, the amendment ordinance was passed in July 2012, and we have two rules which we had to put in place, and that is the enhanced insurance coverage. I know the Law Society has just implemented that, and there are special procedural rules, which is the duty of the DOJ to implement, We consulted the two legal professional bodies, and with the assistance of the judiciary, we are now presenting the two sets of rules to this council. And after this is done, the entire amendment ordinance will be implemented. What is the date of the commencement of the principled ordinance? We'll just talk to the Law Society. For the two sets of rules before us, you can extend the deadline by 21 days, so they will be passed by early December, and then we have to publish a commencement notice for the principal ordinance. So we believe that the implementation date, the commencement date, will be the 1st of March, and we have reached a consensus with the Law Society. Barring unforeseen circumstances, we can implement the new system on the 1st of March. Understood. I hope there will be no more deferral. No, we all work towards that commencement date now. All right. Maybe you can briefly tell us what the amendments are about. Well, I would like to refer members to the markup copy prepared by the Secretariat. For the High Court Amendment number 3 rules, it's about Order 81, Rule 5, judgment or order against firm. The partnership ordinance applies to LLPs. Apart from the other the exceptions in Cap 159 for court proceedings, Order 81 will apply. There are other provisions saying that if you sue the LLP, you don't have to list all the partners' names. You just refer to the firm, and then you can sue or take legal action against the firm. And for the enforcement of judgments, we need to introduce amendments. Because under Order 81, if you get an order or judgment against an ordinary partnership, you can enforce the order against all partners in the partnership. So here we have a new subsection 6, paragraph 6, new paragraph 6. If you have a judgment or order against a firm that is a limited liability partnership, then you may not issue that judgment against a member of the firm unless the member is a partner falling under either A or B. A, the member of the LLP, that is, admitted in the pleading, in the proceedings, that the member is a partner not protected under the legal practitioner's ordinance. So he admits that he's liable. Of course, you can enforce the judgment against the LLP for that particular member. And if there's no admission, then we go to B, either Roman 1 or Roman 2. The member is adjudged in the proceedings. For example, let's say there's a client alleging that there's a negligence of the LLP and the partner is at fault. And the judge ruled that a certain partner is liable. So in the proceedings, you have get a judgment saying that the LLP is liable and also a particular partner is liable, is also liable, then the judgment can be enforced against that partner. But if there's nothing of that nature in the judgment just says that the LLP is liable. And if the client thinks that a certain partner is liable, then another application has to be made. So under Roman B, under Roman 2, the member is adjudged to be such a partner on an application for leave to enforce the judgment or order. So that would be a second action for the client to take. He can apply for leave to enforce the judgment to the court. So it can be enforced against the partner's assets other than the LLP's assets. Well, you expect that everything will be ready on the 1st of March. And this is the last piece of action required. In terms of legislation, yes. What about the Chief Justice agreement? The High Court Rules Committee and also the District Court Rules Committee have come up with the amendments. So the judiciary, in other words, has been fully consulted. The judges are fully aware of the proposed procedures, and they have exercised their powers to make these rules for us. Members, questions? If there's no further question, then I'll follow the usual practice. Any question on the English version? Maybe I should supplement. I've talked about paragraph 6, but there are also some amendments of wording or terms. For example, Rule 5, bracket 2 and bracket 4, we will add words such as subject to paragraph 6 or paragraph 6, because the original provisions are on ordinary partnerships. It's about the change of the text, the wording, but the major amendments is made in paragraph 6. That's clear. Draft, I have a question about drafting. I was looking at the English version, paragraph 6.
Order given against a firm that is a limited liability partnership may not issue against the member of the firm unless the member admitted. 咁啊呢度係嚇，就係in the pleadings that the member is a partner not protected 嚇。OK， 今日跟住 B 啦 ，the member is adjudged to be such a partner。such a partner 即係話係 not protected 咁嘅意思係咪？
係，即係adjudged to be a partner not protected under Part 2AAA of the Legal Practitioners Ordinance。
即係咧，其實 B 嘅讀法係要連埋 A 一齊讀嘅咯。
So we have to read the A together with B. B cannot be independently read. When you talk about such a partner, you mean partner not so protected. Well, this is the drafting approach we adopt. If we want to make B independent, we have to add more words, because the user would read the entire paragraph.
That has all along been the drafting style, because it would be easier for the person reading this provision to understand. Previously, it was independent. Now they are linked together. Normally, you have a definition for member, and you say this member refers to. I think this probably is the new style of drafting, and I think the law draftsman would like to, adopt, a simpler approach to the drafting. Well, I think we also need to look at the district court rules. I think basically those rules are the same, so we don't need to go through it again. Well, in that case, on behalf of the committee, I think that we need an extension. Could the Secretary give us some dates, Chairman? If there should be an extension, then the date to report to the House Committee will be the 20th of November. So I won't be in town on the 20th of November. Could a member, present a report on my behalf to the House Committee? Thank you. So if members wish to move any amendments, deadline for that would be the 25th of November this year. Deadline for moving CSA would be the 2nd of December. We hope that there won't be any further extension. Do members have any other questions? If not, Mr. Ho, could you present a report to the House Committee on my behalf on the 2nd of December? Chairman, if we decide to extend, I think we need to do that on the 4th of November. In that case, I don't need Mr. Ho to stand in on my behalf. As to whether or not we need to invite deputations, I don't think that would be necessary, because there had been extensive consultation already, and the Law Society also has been informed. Thank you.